Good afternoon, one and all present. I am Dr. Jasmeet Gulati, Professor of Law at Jindal Global Law School. I welcome you all to the 19th session of the Global Law Schools Summit. In this session, we will be deliberating upon global legal studies as a discipline. The theme of the session reflects on a new constellation, the inclusive epistemology of global legal studies. I have with me the experts from the field, and it is an honor for me to introduce the panelists for the session. We have for this session Professor Colin Scott, who is the Principal and Vice President of Equality, Diversity and Inclusion from University College Dublin, Ireland. Professor Dr. S. Shanthakumar, who is the Director, Gujarat National Law University, Gandhinagar. I'm also happy to introduce Professor Dr. Shivprasad Swaminathan, who is the Professor and Associate Dean, Jindal Global Law School, and Professor Dr. Mizanur Rahaman, who is the Assistant Director of Center for Postgraduate Legal Studies at Jindal Global University. For the audience watching us on YouTube, I would like to share with you the format of the session, where I shall briefly introduce the theme of the session, which will be followed by the Q&A round, where we will hear the views of our panelists. And we also have certain questions framed for them, but we will be inviting questions from the audience as well. Global legal studies has only emerged out of global studies, which is not the discipline sensu stricto, but it has an interdisciplinary approach and is impacted by other disciplines, including economics, politics, history, sociology, and international relations. A new generation of global legal study scholarship is building by investigating the depth of law's power for people and for their governments. Mark Fathi Masood, in his recent article on reflections on the future of global legal studies, states that the future of global legal studies will involve bridging the study of law with politics, society, history, religion, and human behavior. The approach and the ideology concerning the global legal studies is inclusive insofar as its subjects and objects are concerned. It has to overcome the challenges put forth by the modernity and postmodernism. The fading away of physical boundaries because of globalization and the emergence of globalizing world has to be kept in mind while talking of new kind of governance model, which would be acceptable for deliberations and practical utilities for the new generation of lawyers. The epistemology that has developed analyzes the changes that are being brought about by globalization and its implications, which are not only legal, but affects global economy, global trade, global relations, global politics, with all its challenges, for instance, climate change, including global warming. Global legal studies would include global processes along with the challenges, as mentioned, for example, global warming, ozone depletion, etc. The actors in the globalizing world and the globalizing legal order, which are no more limited to legal persons, includes the multinational corporations, the elites, NGOs, social networks, cultural groups, market forces, and so forth, which are very much part of the global legal studies. We are talking of this new constellation that has come out of the era of globalization, where while reading global legal studies as a new approach is required, which would be based on all these disciplines. Global studies create global citizens. And similarly, global legal studies would create a new army of global legal professionals who would have an inclusive approach, which would be interdisciplinary rather than comparative. On the other hand, global forces may also trigger local and domestic reactions that deepen tensions. Global forces sometimes encourage new forms of economic and legal integration that harmonizes across local legal and economic systems. It is expected that they would be more tolerant and inquisitive. The world is reorganizing itself to deal with such challenges and more. For example, recently we saw the global response through the global fight against COVID-19. The approach was global rather than international because the goal was single. That is, fighting COVID-19 through vaccinations and social distancing. Since the problem is global, therefore the problem-solving techniques are also to be employed globally rather than locally. The social distancing, in fact, brought the world together as we see even today at one platform where through virtual proximity, the time and space became meaningless. It's a new world order that reflects the collective spirit of global. The purpose of this session is to explore the epistemological inquiry that global legal studies provides us to understand the conditions, challenges, demands, and needs of the contemporary times, giving due consideration to the history and having foresight for the future. Having discussed the theme of this session, I would like to invite the speakers to give their views on some of the questions that we have in mind. I'm going to invite Professor Colin Scott to please share your views on the different countries that are following different legal systems. And even where the same legal system is followed, it is tailor-made to the needs of its own society. A global legal approach imagines a sense of commonality and universalization across borders. How would such differences be accommodated then? For example, judges or even arbitrators of different international courts and tribunals, they often belong to different legal systems. And this often results in them adopting a lens which is colored with their domestic experience while adjudicating matters. So what do you think about this?
Thank you very much. And thank you for the invitation to speak. It's a great visionary activity, I think, to run this global conference on the challenges around global legal studies. And I'm very pleased to be involved. Looking at your question about how we deal with the challenges of different legal systems, creating a problem for the operation of global law, I think the answer might come at a number of different levels. Clearly, national legal systems do have different norms, different procedures that make the operation of law across borders very, very difficult. But from my own perspective, some of that focus on national rules and national procedures is falling away because of the operation of law transnationally. So in many instances, we are thinking about transnational regimes in which the parties to agreements, which may be contracts or they may be treaties, are setting down norms and also procedures for vindicating those norms. And in that context, the national rules and national courts are perhaps less significant than we might at first think. And even if we said, well, the national rules and the national procedures and institutions are very important, even if we said that, we might still find that transnational institutional structures and procedures and norms operated without regard to national level. And so from a normative perspective, we might be limited by what's happening in practice around the emergence of regimes for which national procedures and national norms are less important. Now, that said, there have, of course, been exercises to try and create more uniformity around rules, for example, relating to contracts and trade. And that process is, I think, not unimportant, but that also, of course, creates norms and process levels above the state. And what I see overall, and might be helpful just to conclude my remarks on this topic, is a form of legal pluralism emerging, in which we have the national alongside the transnational and also alongside the international, with efforts to create more uniform norms. So it's part of our role, I think, is to understand, explore, and to map these changes and this emergence of a pluralistic approach both to norms and procedures. That's one of the key challenges, I think, for global legal studies. Thank you.
Thank you, Professor Scott. I would like to invite Professor Shanthakumar for my next question. It is a matter of academic curiosity as well as practical relevance to explore how this global system of laws is changing the existing system. Is it directed towards expanding the scope of the existing systems, or is it growing with the intention to encompass all systems of laws, for instance, global administrative law, global constitutionalism, global sports law, or global lex mercatoria, leading to the global system becoming the grand norm that determines relations across the denominations of governance? Professor Shanthakumar.
Thank you. At the outset, I thank Jindal for organizing this very intellectually stimulating summit and with this session on global legal studies. So my special appreciations to Professor Raj and to all the professors there who are organizing this summit. Now, coming to this question, if you look at the global system of law, it is so diverse. So we all accept that it's very diverse, and the impact of it is felt in all the domains. And therefore, the academic curiosity, no doubt, it provides areas on which the system can be improved. It is with the research in the legal system, a well-effective global legal system can be achieved. The global system of laws has been revolutionized with the intrusion of governmental and non-governmental international organizations. The impact can be seen in the public and private international domain. On the one hand, you see organizations like ECOSOC has formulated a strong organizational structure for the protection of human rights based on the Vienna Convention of 1994, ensuring that the nations formulate the Human Rights Act under the domestic law of multiple nations, and has formulated the International Human Rights Commission for providing protection where the state fails. In fact, it is the annual report of the HRC that is, if you look at the annual report, that is the result of research that enables us actually, enables us to point out to the flaws in that system. If you look at the private domain, it is the academic curiosity that has made UNCITRAL formulate the working groups concentrating on different areas, such as the working group on e-commerce and the working group on arbitration, etc. And the UNCTAD has added in formulating the Hamburg and the Rotterdam Conventions on carriage of goods by sea. The UNCITRAL principles on commercial contracting is another example of it. It is therefore, my opinion is that this system is growing with the intention to encompass all the systems of law, leading to a global system becoming the grand norm. So that is my view, and thanks for this opportunity.
Thank you, Professor Shanthakumar. I would like to invite Professor Shivprasad Swaminathan's views on what is the epistemic motive of global legal studies? Is it to harmonize the legal system or clarify the differences and divergences in the legal systems?
Thank you very much for that question, Jasmeet. Now, I think that here we should begin with the word epistema itself, the Greek word epistema, from which the term epistemology comes. Now, epistema is something that in Greek philosophy also always related to a science, and it is science that has universalizing ambition. But the law, especially the common law that we have inherited in India, and that Professor Scott has also inherited in Ireland, that has always been regarded as a skill, and that in Greek was called as a techne, which is quite different from an epistema. And when it comes to skill, the mode of cognizing that area is not through scientific knowledge or through rules and norms, but rather tacit knowledge. And tacit knowledge is knowledge that cannot be reduced to the form of rules, norms, and propositions. So there is little surprise here that the civil law, which is spoken of in terms of a science, is understood in terms of norms and rules and codes. And of course, the civil law codes are great examples of that, while the common law is not. And the key thing about tacit knowledge is that it is acquired through a form of osmosis. By absorbing culture, it's a form of learning by doing, as it were. And if the law, or at least some systems of law, such as the common law, are largely dominated by tacit knowledge, I think that it must give us pause, because what that means is that here is a system that cannot be that easily understood from afar by a universalist or a globalist epistemology. Now, closer to my own field, so I work in legal theory. And the one thing that we have seen recently is that there has been an explosion of theories in various areas of law, like, for example, contract law, which have these universalist ambitions. So there are scholars sitting in Argentina, Chile, UK, Singapore, Canada, and so on and so forth, who are creating universalist contract theories. These are theories that try to uncover the rationalist structure, the epistemological basis of all of contract law, whatever that means. So these are not theories of any jurisdiction in particular. And so there is definitely something very odd about these theories, because if they are a theory of every place, then they are also a theory of no place. And the law in action, the law in courts, has absolutely no relation to these theories, and this has actually led to a large number of legal theorists calling for a sort of moratorium on this form of theorizing, which fills up volumes, but does nothing on the ground. And this reminds me of the words of the Roman poet Horace. Mountains were moved, but they only produced a mouse. And I think that that's one of the biggest challenges in the way of when it comes to the epistemology of global legal studies. Thanks.
Thank you, Professor Shiv. Thank you for the inputs. My next question I would want to ask Professor Mizanur. Is global legal studies an aspirational academic pursuit without any practical significance? Or is it a nascent epistemology meant to transform the way we look at the world? Professor Mizanur? I think I might come back to him after later, after some time. So
sorry, my mic was muted. Sorry.
That's all right.
Sorry. So thanks, Jasmeet, for this question, and thanks for the invitation to speak on this occasion. I will be reflecting on the question. I think I will take the lead from Shivprasad, where he raised the idea of epistemology, which obviously not going by the word strict meaning of the term episteme, which is kind of a knowledge, but it's more about the way of looking, a way of seeing, how we look in a particular phenomenon or in a particular arena, whatever you say. So law as a discipline, I think, is a kind of closed discipline historically or conventionally, where if you look into the theory of Nicholas Luhmann, who actually kind of pointed out that a legal system is a kind of self-contained system. Obviously, there was something that he proposed that it's the systems actually interact. So it's not really that the discipline of law, the legal education, or coming from that kind of dimension, that global legal studies is not simply an aspiration. I think, to kind of, considering historically that law has obviously a very complex, or the legal education obviously has a complex relationship with the practice of law, but somehow, if we look into the meaning of practice, how law actually changes over a period of time, that is kind of influenced by the practice, what is happening on the ground, that somehow actually influence, somehow actually push for the changes that occur in the discipline of law, or the way we think about the law, or the way we look into how law operates. And the same thing actually happened happening at the global level. When we're looking how actually law operates at the global level, we are seeing increasing interaction between the different legal fields, or if you call soft fields, or different levels. And that's why the idea of the legal pluralism, or the global legal pluralism, so different scholars actually termed this phenomena, this interaction. So from a point of view of whether it's an aspiration or it's a practical utility of the global legal studies, I think we should focus on the term or the terminology. What does actually the global means? And if the term global means an increasing interactions, and therefore it's an imperative that we should focus on the relationship between the global. And obviously the term global does not simply means big. The global actually is simply a global local interaction. And somehow what happens at the global level, or the international level, the transnational level, somehow that affects or kind of interacts what is happening at the local level. And what is happening at the local level, such as if you look into the social movements or the labor movements, what is happening at the local level, somehow also kind of translates or kind of interacts or kind of moves kind of bottom up perspective that changes the global law, or the way we look into the operation of the law at the global level. So in a sense that I will say that's obviously in one sense academically might be it's an aspiration, or obviously we can the debate, we can kind of begin and keep the conversation going. What does the term global means, and what does the term global legal studies means? And obviously there are debates, how to actually think about the global, and it's kind of the complexity of the global the multifaceted, multi-sided nature of the global. And that obviously translates to global legal studies. The global legal studies are going to need to be kind of, need to be opened up for different voices. And coming to that from there, if you look into the practical utility, and obviously we have the aspiration to teach our students in the next generation of lawyers or professionals how to actually think and how to think about the law and how to actually kind of open their mind for thinking more broadly. I mean, if the term global means big and broad, at the same time, it also includes the local, which is small, then how the big and the small, how the global and the local actually interacts, and how that brings a lot of changes that happening at the domestic level, at the regional level, or the international level, or even if you use the term transnational level. So it's an aspiration in terms of debate, in terms of conversation, in terms of thinking differently. So that's kind of epistemological excavation, how we actually think about it. At the same time, you also have an imperative to kind of teach our students how to think more broadly, looking into law in a broader, pluralistic perspective. So, thank you.
Thank you, Professor Mizanur. Thank you for your views on this. I would like to invite views from Professor Shanthakumar. With the increasing challenges of the 21st century, does global legal studies acknowledge the limitations of the current system of laws? Is global legal studies an exploration of how to make inclusivity the norm? Professor Shanthakumar, can we have your views on this, please?
Can I request you to have the question again?
Yes, please. So I was just asking that with the increasing challenges of the 21st century, does global legal studies acknowledge the limitations of the current system of laws? Is global legal studies an exploration of how to make inclusivity the norm?
So if we look at the global legal studies, the global legal studies actually looks into an advanced and systematic understanding of specialized subject areas, which affords to an ideal platform for students to acquire expertise and knowledge informed by research-led teaching. So this is an approach. So this global legal studies actually takes a global approach to questions of law and legal regulation. And it includes a comparative research with both the national and international case studies. So therefore, I don't personally feel that this global legal studies movement will be anything away from having an inclusive approach. It will also have an inclusive approach, because having a global approach to questions of law, it includes a comparative approach, and comparative approach, of course, you take cognizance of everything what happens locally, nationally, and globally.
All right. Thank you. Thank you, Professor Shanthakumar. I would like to invite Professor Scott's views on my next question. That is, in today's day and age, sovereignty of states still holds value. Different countries adopt different approaches when it comes to the participatory character or of its non-state actors. In such a background, how would the global approach be able to accommodate the differences? Professor Scott.
Thanks for the question about sovereignty. So
yeah,
I think that perhaps there are two aspects to the question. Given the variation in the ways that non-state actors are recognized within different legal systems, not simply in terms of participation, but also the mechanisms to make, to give validity to, and to implement legal norms. You know, how could difference between those different approaches be accommodated? But given that non-state actors will act whether or not the global approach accommodates them, it's more important perhaps to recognize the power and importance of non-state actors, firms, associations of firms, but also NGOs. I think this is where the interface with political studies and international relations is very important, to recognize power in quite a number of locations. There are numerous private regimes for setting standards globally, which are non-state and have a loose linkage to the UN. And there are also, as we've heard already, a variety of international regimes, which are, the international regimes, of course, are sometimes talked about as if pooling of sovereignty, in the sense of states working together to develop solutions to common problems. But the non-state activity is very difficult to characterize in that way, and does, I think, raise a challenge for traditional conceptions of sovereignty, which can either be used to say that these private actions are illegitimate and raise real democratic challenges, or perhaps call for a different theorization. And I think of John Keene's work on democracy, which looks beyond representative democracy to identify the roles of many different non-state actors in monitoring state activity and in providing alternative to representative democracy. Not that I think representative democracy is over, but rather that it is being complemented perhaps by a range of other actors and mechanisms. I mean, if I could come back and link this to the question about epistemology. We've talked about law as a discipline. I wonder whether law is a discipline or whether it's a field of practice to which legal education is a significant contributor. And if it is a field of practice, of course, it is also a field of study and research. But from a research perspective, law as a field is not just about the articulation of legal norms and processes, but also understanding the wider impact of law and the changing role of law. And I think that's where the role of the law and society research, socio-legal research, in projecting law as not just a field of practice, but also a field of study, is really important. And it bears on the question of sovereignty, because from a field of practice point of view, we might be very frustrated by these changes in norms and practices and the impact on sovereignty. But from a field of study, field of research perspective, it opens up an extraordinary range of different legal processes for us to understand from perhaps a perspective of legal pluralism or some other perspective that recognizes the range of different sources of legal power, not just those we've traditionally identified as being from the sovereign states or the pooling of sovereignty through the international.
All right. Thank you, Professor Scott. Very well said. In fact, in the previous question also, you highlighted about legal pluralism, and I was just trying to link this to what you were saying regarding the sovereignty, and at the same time also being when we consider the role of non-state actors, and when state has not much role to play in there. So I'm coming back to Professor Shiv, and I have a question for you, Professor Shiv, that if global legal studies would help in reimagining or reorganizing the world, then shouldn't the very foundation that needs to be reimagined or reorganized be corrected first?
That's I think that's a very foundational question that goes back to the issues of epistemology that we were exploring previously. And I think that it would be very helpful to actually look at the past in order to see what the future will actually, in fact, look like. Because even though it was not called as as a globalizing revolution, we have already seen this happen with English law in the 19th century. A very similar epistemological revolution. Uh, uh, so until the 19th century, the English law was never taught at universities. So it was always regarded as something to be apprenticed into by reading in chambers or by hanging out in the Inns of Court, having a certain number of dinners, as they used to call it. Now, all of this changed in a kind of a rationalistic fervor that swept 19th century England, starting with Bentham and codification. Uh, there was also a parliamentary committee on the reform of legal education in the year 1845. And all of this actually led to the birth of a new form of pedagogy at places like Oxford, Cambridge, London, etc. Now, prior to this, there were hardly any chairs of English law, and I can only think of two chairs of English law before that. One was the Vinerian chair that was set up in the year 1758 that was occupied by Blackstone. And there was one in Cambridge, I think it was the Downing chair. And all of this changed in the 19th century when new chairs were set up in Oxford, Cambridge, London. And Albert, when Dicey's inaugural lecture, even the title of that lecture is extremely instructive, and it has a direct connection to the question you asked, Jasmeet. So he says, can the English law be taught at universities? That is the title of his lecture. And he does recognize that the English law has always been regarded as a skill or a form of practice, as Professor Scott put it earlier. And he equated the lawyer to a brickmaker who had an expertise in a certain skill. And the question was that what can we offer to this brickmaker? And Dicey said that we professors are actually going to offer you a science, a science that actually underlies your craft. Now, according to many scholars, this actually creates a tension. Like, for example, Michael Loban says that this creates a tension between the lecture room and the courtroom in English law, which is actually still not resolved. Because what this does is that it changes the very epistemological framework of how you, in fact, look at the law. Because the model that was being given by Dicey was the model of rules and norms, etc., that were borrowed from the civil law world. And it is these very same professors like Dicey who also started writing textbooks where the law was portrayed in the form of rules and exceptions. Incidentally, if you look at Dicey's textbook, even now, Dicey and Morris on private international law, it is still in the form of rules and exceptions, and that actually creates a very misleading impression, because that is not the epistemological structure of the of the law, of the practicing lawyer, and the practicing lawyer knows that this academic form of law is actually far divorced from the reality of the English common law. Let me just give you one other example of this, and that again speaks to the same point of about how do you know the law and the epistemology of the law. So it was at this time that for the first time the need was felt to give a kind of formula for trying to find out the ratio of a case. And the need for this was felt because now suddenly you have transformed your case law into a system of rules where the assumption is that in each case you will also find a rule which is in the ratio of that case. And so if you so if you even go to an elementary book on legal methods, you will find that all of these debates only begin in the 1890s. How do you exactly find the ratio of a case? And quite embarrassingly, you still don't have an answer because of this tension that that the epistemological structure that is being used to actually cognize this underlying practice or discipline itself doesn't actually is not actually suited for that at all. And so I feel that the answer to this, to the question you asked, therefore, is not at all a straightforward one, because I think that these tensions run very deep, and I think that it's not that straightforward to actually resolve these tensions, because the very fundamental nature of these practices is quite different, according to me. Thanks.
Thank you, Professor Shiv. I understand from where you're coming that these tensions are very deep and it's not actually easy. And that's why the need to frame such questions, just to know whether we are able to reach any conclusions. I'm coming back to Professor Mizanur for his views on my next question. That is, a criticism of the global approach is that it results in isolation of disciplines. That is, disciplines have a tendency to divorce themselves from others. And by adopting such an approach for the discipline of law, wouldn't one be moving backward instead of forward towards one's positivistic lineage?
Thanks, Jasmeet, for the question. So I will kind of go back and kind of start from what I said before, that historically and traditionally, law has been, as a discipline, has been kind of looked as a kind of closed system. It actually kind of sometimes resists, sometimes rejects outside perspectives, outside views. And that somehow kind of contested and changed later with the law and society approach and many other law and approaches that kind of started later. And when you look into in the past 10, 15 years with the emergence of globalization, suddenly there's a shift from a jurisdiction-based positivistic outlook. From there, suddenly there's a sudden change to understand and look into the law as a broader discipline that kind of change somehow impacted by the global processes. And if we accept that the term global includes or encompasses multiple voices, is a multi-layered, multi-sided, includes multiple experiences, voices, and conversations, then obviously, if we stick to this positivistic, self-contained, closed a system of thinking, or legal thinking, or the legal system, then definitely we are going back to what we studied, or the foundational understanding of what does the law means and how the law kind of operates within territorial boundaries. So somehow, with the emergence of globalization, there is a kind of not just the deterritorialization of the laws or the legal processes, but there is also a deterritorialization of thinking. So thinking somehow moved, the legal thinking or the thinking about the law, thinking about the law's functioning, operation somehow kind of moved from the disciplinary boundaries to include, to kind of encompass thinking from other disciplines. And not only that, and if you kind of look into the very term global legal studies, which actually came from or borrowed from the global studies itself, and even in that sub-discipline or discipline, or even not even a discipline, the global studies, where many scholars actually talked about decolonizing the global studies. And that also kind of brings us to think about decolonizing legal thinking, not just having a kind of colonized thinking of how law operates, how law functions. And I just want to kind of close this conversation. I mean, my views kind of pointing to William Twining's Montesquieu lecture in 2011 on globalization and legal scholarship, where he actually pointed out that to understand the relationship between law and globalization, that obviously that's the aspiration that we should kind of teach our students the relationship between the global and the legal, requires a kind of also kind of rejecting, resisting, and kind of moving beyond the ethnocentric biases of the Western law. And that obviously, so moving forward, that is a kind of progressive thinking about including multiple voices into the understanding of the global law, the global legal processes. And that also includes voices from the South, somehow, which remain marginalized in the global studies itself, and coming from the global legal thinking. So definitely, it kind of moving forward, taking forward the conversation regarding the global legal studies includes moving forward. It's kind of progressing towards something which is unsettled, which is kind of require more thinking.
Thank you, Professor Mizanur. So, I mean, we, as you said, that we're going to move forward to that. And I'm just thinking about the discontinuity in a sense. And for my last question, I'm inviting Professor Shanthakumar to please address this last question to come from the audience side. That if discontinuity, in a sense, allows for a fresh start, which Professor Mizanur also talked about, what would become of the voices that were previously suppressed? For instance, if the voices or experiences of the third world nations were not taken into consideration in describing international legal history, wouldn't an approach that allows for a fresh start belittle their contribution to history? Also, if the international legal history is not fully representative of all voices, including the third world, on what basis a conclusion can be drawn that there has been a discontinuity to begin with?
Yeah, thanks for this question. A very interesting question. If we look at global legal studies, so global legal studies, as rightly pointed out by one of the previous speakers, is a nascent epistemology, which is meant to transform the way we look at the world. It actually focuses on, and it should focus on intersections of global and domestic legal regimes, markets, politics, history, technologies, and cultures. It also should look into the way transnational law shapes and is shaped by the circumstances of its development, application, interpretation, and contestation in a wide variety of contexts. In fact, some of them transcending national borders. In other words, it is an understanding and analysis of domestic involvements in globalization and transnational law. Since globalization and transnationalism, they alter the very meaning of territory in various ways. Therefore, my view is that global legal studies actually looks into the development and transition, including the rule of law, law and development, comparative economic law, trade, sustainable development, human rights, democracy, and governance, including comparative constitutionalism, implementing socio-economic rights, and humanitarianism. Therefore, I personally feel that it is definitely a required academic pursuit with a lot of practical significance, and also to transform the way we look at the legal studies in this world. So this is what I wish to see for this.
Thank you, Professor Shanthakumar, for the inputs. So I have one more question from the audience, and I would like to invite the views from Professor Colin. It is pertaining to globalization. Professor Scott, I'm addressing it to you, that in a period of increasing globalization and consequent practice and study of global adjudicatory procedures and legal paradigms, do universalist theories assist in creating efficient normative legal frameworks?
Thanks. Yeah, so there certainly is work to create more efficient legal frameworks. There's work done through, as we've mentioned, the various international bodies, and there are also private endeavors to try and create more effective legal frameworks. Indeed, some of these are based on sort of commercial objectives. You think about in the area of international swaps and derivatives, we see the development of instruments privately to try to get a reasonably universal application of norms to create expectations around contracts that can be common across different jurisdictions, even though they're implemented privately. But I think that aspiration to effective universal norms is really only a small part of what is signaled by global studies. And I think global legal studies, and I think a lot of the opportunity comes from some of the things that have been mentioned by colleagues on the panel here around addressing power, inequalities. And I think one of the opportunities we have is to more effectively link global legal studies to the UN Sustainable Development Goals, and to think about hunger and poverty, to think about gender inequality. I notice we're chaired by you, Professor Gulati, but we're four men talking about these issues, and there's an opportunity for obviously a broader base for discussion. And then the theme of partnership within the UN Sustainable Development Goals, how we are partnering today for this discussion across boundaries, but how we partner more broadly across disciplines, how we partner institutionally, how we partner with governments, partner with NGOs, partner internationally. There are so many themes in the UN Sustainable Development Goals that I think global legal studies, if it engaged thoroughly with those themes and with other disciplines, could advance the most urgent challenges that we face as a society, as a global society, as has been highlighted around climate, around food security, around peace and security, and wider inequalities. And I think if global legal studies is not addressing those urgent societal challenges, then it is failing as a field of endeavor. And that's the challenge I set for us all, including myself.
Thank you, Professor Scott. Very well said. And with your concluding remarks, where you highlighted the challenges also that we all have to face, along with welcoming this new move, which has already set in, and that we have also going to start talking about this as a new discipline of global legal studies. So thank you very much. I would like to take this opportunity to thank all the panelists on behalf of Jindal Global University, Jindal Global Law School, for sparing time for us and giving your inputs, giving your views and your expertise, expert comments for this particular session. I thank you all, and it has been a great learning experience for me as well.